instances where you guys are married, one party dies. What happens? Is it automatically? Is it 50-50? Is the property automatically shifted to the other spouse? Is that the
That's
case?
also a very good question, because now these matters come up legally a lot, right? So now there are two types. We have death with a will and death without a will. So that is the testate and intestate. So intestate means you died without a will, and testate means that you died with a will. So a will is more or less an expression of your intent, right, of sharing the property. So someone who owns property can share the particular property in the way or manner that he deems fit. So a man who is married can decide that this is my property, and I want to share it 30% to my wife, 20% to my firstborn, 30% to my secondborn. I hope you got it. And then 20% to my parents. He can decide to share it in any way he deems fit. The only law is that at least if you have property and you have a wife that you are living, just give her a sort of maintenance. She can apply for maintenance. So from the property, she wants a bit of maintenance. So you are not legally obligated to give your wife 50-50 share in your property upon death. And your wife is not also obligated to do same. I hope you got it. The property upon death can be shared according to the will, the full expression of the man or the woman, the person who died, the deceased person. But for the intestate, then there's an issue, because intestate means the person died without a will, right? So we have the intestate succession law, PNDCL 111. It says that the wife and children are entitled to a portion of the property. So they have percentages. That if you marry and you have one child, here's how the property should be shared. If you married and you died without a child, here's how the property should be shared. So in this case, there is a fixed percentage that will go to the wife, fixed percentage that will go to the children. Even if the person has like a parent, there'll be a percentage that goes to the parent. So that happens when you die without a will. But if you die with a will, you fully express how the property should be shared. Yes.
What is the legal implication of purchasing a house or a property together as a couple? Well, there's a notion that when you purchase a property, it is for both of you, is for the two automatically. Is that it?
Well, that is also a general notion.
Yeah, that's a general.
So there are two things, right? In respect of purchasing a property, right? Two things. We have individual property, and then we have jointly owned property. So when I'm married to my wife, it is assumed under law that any property that we obtain is jointly owned. That is even under the Constitution.
Can you take it again? Can you take that again?
Yes. So Article 22 of the Constitution says that when a party, any property that is obtained by the parties in the marriage, during the marriage, is jointly owned property. It's assumed to be jointly owned property.
From both parties.
Both parties. So this one isn't a male or
you mean it's from both parties?
Yes, from both parties. So even if a wife acquires property, she buys land, she even builds on the land. During the marriage, there's a presumption that it is jointly owned. And I'll explain the reasons for that particular presumption. Yes. So now this issue came out of as I told you, the legal union between the persons, and the fact that people are regarded as one when they marry. Now, when a man and a woman marry, more or less, it is deemed that the man works, the woman also works, most of the time, or sometimes the woman can decide to step back a bit and raise the family. Now the issue is that we don't want one party to have an advantage over the other. That this woman spent 15 years of her life taking care of the family, only to end up losing everything just because the man acquired properties for his own. So there is a presumption in the highest law of the land.
Yeah, but lawyer, see, when a woman also stays at home for 15 years, looking after the family, the kids are for both also. So you, the woman, you gain some form of some form of advantage also, as to compare to the man. So the kids, obviously, you guys are not splitting the kids, but why is it that the man's property is what we are splitting? That's the notion actually. That's the main notion out there. Because I've never really heard a woman's property being split In two.
Oh, they've done that a lot.
Really?
Yes, they've done that a lot. Trust me, it's even in the law, the Matrimonial Causes Act.
Okay.
Right? It says that the fact they'll not look at whether it's male or female. They'll look at the income, what the parties earn within the marriage. When they come to split properties, especially upon divorce, and even the man can apply for maintenance from his wife.
Oh, I see.
Yes, so there are cases where popular celebrities marry. The lady is a very rich popular celebrity, and then she marries a normal individual, like a man who is not equally as rich. The man can apply for maintenance when they divorce because he has brought his level of living to a standard that he cannot afford on his own now. So more or less, the issue comes out as a result of the fact that under normal relations with both genders, that is the male and the female, everyone assumes that the females are the ones who suffer in the marriage.
I don't do too much work. You are the guy who goes out and work and bring money.
So of course she's also bearing you kids. She's also running the house. So why wouldn't you let your wife to enjoy some? That kind of thing. 50-50. Yes. So there was this thing known as presumption of equality. There were many people who presumed that when they divorce, split the property 50-50. Yes. It was a very strong argument until the Supreme Court said in a recent case, AJ, that no, if you marry, you can actually have your own individual property. So how do you get your own individual property as a man or as a woman, right? For example, I marry and my parents give me a gift, and that gift is a house. Why would my wife claim that we have to share the property 50-50? It's my personal property because it was given to me as a gift. I marry and I take a personal loan. So I go to the bank and take a personal loan and attach it to maybe my personal assets that I had before the marriage. So why is it that when I use this personal loan to build a business or to build a house, my wife should have 50-50? I hope you are getting me. It's my personal loan. I paid the loan for my own resources. Probably I had property before I married. So number one, property before marriage is not split 50-50, or it's not split amongst the couple. It's not deemed to be jointly owned. Any property obtained before the marriage. Yes. Now
it's for you and
you alone. So now most men will decide to rather obtain all the properties before the marriage. Yeah, because before the marriage, because they know that once they marry, whatever they obtain after, they will say that the wife contributed to it. I hope you got it. So property obtained before the marriage is not presumed to be joint property. The law is property obtained within or during the marriage is presumed to be joint. So it is a presumption. So there is this word, rebuttable. You can change the presumption. You can prove to the court that no, this presumption doesn't work for us. Why? Because maybe I got this house that you see behind us, maybe as a gift. So this beautiful house is a gift. So why is it that my wife now wants it 50-50? Me, I've been working and I got a gift. So why does my wife?
If you want this house as a gift to your wife or your spouse, kindly hit us on your screens.
We'll do that.
The telephone numbers will be on your screens right about now. Yes. And this is the 7-Eleven. This is a very beautiful property we've been able to put together, and it is. Right. Okay. So what happens also if the demise party was also owing before dying? Does it mean that the parties also alive would have equal distribution of liabilities? Yes.
Well,
does it mean that?
Well, there are also factors that pertain to this, right? So if you have a property and you die, right, the property is part of the estate of the deceased person. So before they share the estate of the deceased person, they remove all the debts. I hope you got it. So if a man dies and says, I'm giving 50% of my property to my wife and 50% to my children, they will remove all the debt first before they now calculate the 50%. I hope you got it. Yes, so that you not come and impose the liability on the kids first. The liability will be imposed on the estate of the deceased person. I hope you got it. Now, if the estate of the deceased person can't pay for the debt, then that's it. He is dead. I hope you are getting it. The particular debt will not automatically transfer to their children unless there are express intentions on an agreement. That provides for debt sharing or transfer of the debt. So usually, let's say for bank loans, the building is a collateral. So if they cannot, get the money back from you because you are deceased, they'll actually come and attach the building as they'll sell the building and then they'll use the proceeds to pay back the debt.
Okay.
I hope you are getting me. So the estate of the person, you don't share the property before you pay the debt. You pay the debt before you share the property of the person. I hope you got it.
Okay. Okay.